Hello, and welcome to Let the Record Show, a Sivia Law podcast, episode number 2. I'm Todd Sivia, the owner of Sivia Law, where we help you through life's transitions. Today, we're going to be talking about special needs children turning the age of 18. This is probably a big issue with regards to most parents that have adult children who have special needs. A lot of times when a family with a child with special needs comes into the office, they're really trying to figure out all the different options. Well, they think that they don't have many options. They believe that they have to go to a court in order to get a resolution and to make financial and healthcare decisions for their children. And a lot of times that may not be the case. You know, I've had clients that have gone to other attorneys and they say, oh, you have to go and get this thing called a guardianship. And I meet with the individual and it may not be as clear cut as what a person may think. So let's talk about the 3 ways to handle children with special needs. So there truly is 3 ways in handling special needs children. You have the option of a power of attorney, the option of a limited guardianship, or there's full-fledged guardianship. So let's talk about the full-fledged guardianships and get those out of the way. If the individual is unable to make financial and healthcare decisions, and it's very, very clear, they have something along the lines of, they're unable to speak, they're unable to communicate, but they're over the age of 18. Because under the law, anybody over the age of 18, their parents no longer are able to make their healthcare and financial decisions. So, and this doesn't just resolve around just special needs children. This is talking about all children. So all children as of the age of 18, their parents no longer can find out what they're getting on the school report card unless that child gives them the authorization. They no longer are authorized to see their bank accounts and anything related to that. They're also not allowed to make healthcare and financial decisions. So this is very, very important for all children over the age of 18, but primarily it's a bigger issue for those with special needs children. So at age 18, there has to be a plan. And that plan, sometimes, especially if they are not communicatable, we've got to go through guardianship. But, in today, there's people that have autism that are making great strides in the fields of science and medicine and things of that sort. So, just because you've been diagnosed with some kind of disease does not mean that you have or you're required to give up your legal rights. And a lot of people don't realize that by going through a guardianship, you're asking a child to give up certain rights. A lot of times that may not be needed. They may be able to make financial decisions on their own, or they may need some help. So, it's very clear, age of 18, we've got to go through guardianship. But for some people, there's a clear question of whether or not we could go power of attorney or limited guardianship. And we start getting into nuances of stuff, things of that sort. So I had a client just recently came into the office, and the person was able to communicate, was able to make financial decisions on their own, but there was occasions where they had mental illness, and they may need to be forced to take meds or be forced into a hospital setting. So if a client is able to communicate who they want to make financial decisions for them, who they want to make medical decisions for them, those individuals are clear candidates for power of attorney. You don't need to go through court action. You don't need to spend a whole bunch of money on us attorneys. Now, most attorneys love it when you spend the money on us, but let's talk about the true solution. And the solution to the problem may only be a power of attorney, and instead of spending money. So a power of attorney is basically a piece of paper that authorizes you, the parent, to be able to make financial decisions or healthcare decisions on that person's behalf. And there's a couple types of power of attorney called an immediate power of attorney. And that immediate power of attorney means that the person or the agent, a lot of times in special needs circumstances, it's their parent, has the authority to make immediate decisions. So they can help them pay their bills. They can help them make healthcare decisions. And they can be involved in those decision-making process. But then there's something called a springing power of attorney. So a springing power of attorney, and this is more useful for most people. It springs to life when the person has deemed to be incapacitated. They're not able to make financial decisions or healthcare decisions. So somebody that has a mental illness would be a perfect example of somebody that may need a springing power of attorney, where that springs to life and allows you the authority to make financial and healthcare decisions at the time that they are deemed to be incapacitated. Then we get into what's called a limited guardianship. So we've got power of attorneys, we've got regular guardianship. But then we have a limited guardianship. And basically, a limited guardianship entails where somebody may need help with finances, but they can make healthcare decisions. So, that's positive because it's very limited. It means that they can still drive, they can still do certain things, but it's limited to a certain type of area, either finances or healthcare. So limited are there, and you don't have to go through full-blown guardianship, but you still have to file with the court. You're still filing a lawsuit essentially against your child to claim that they are incapacitated in some form or fashion. But it also requires a report. If you are a financial guardian, you have to report on everything that was spent on that child every single year. So you've got to provide a report to the court about what's being spent, how it's being spent, and the like. Same thing with healthcare. You got to report every 3 years. So you're in the courtroom, whether it's finances, at least once a year. If it's healthcare, it's every 3 years. And you've got to report to the court and ensure that the court is aware of what's going on. And you are required to report. Compare that to a power of attorney. You've got to report to the child and say, hey, you still have money and things of that sort. And you can't not spend the money, or, you spend it on your own purposes. So there's still fiduciary responsibilities with it, but there's no reporting requirement. You don't have to get an attorney and pay attorney's fees every time you go to the courthouse, because there is no courthouse with a power of attorney. So, like a power of attorney is fairly cheap compared to a guardianship. Our standard retainer for guardianships, even on a limited basis, is anywhere between $2,000 to $3,000, versus a power of attorney is very, very minimal, 20% at the most of that. So you have to look at, there's a whole analysis that our attorneys go through when we determine whether or not a person should go through guardianship or they qualify for power of attorney. We know about these things, and we're very comfortable utilizing the mechanisms within the statute to ensure that a client does not have to overspend their issues. One of our key core values within our organization is stewardship. Making sure that we're handling the issue related to the client and how to be efficient with your money, paying for our services. So, it's not just us looking out for money for you. We want to make sure that, we're being good stewards, not only of clients' money, but also, the child's money, because the child has to pay for the attorney. If we can get away with using power of attorneys for a client, let's use it. A lot of attorneys think, a person has Down syndrome or they have autism. It's an automatic. We have to go through guardianship, and an experienced elder law or special needs attorney will know, hey, maybe we don't need to go that far. Maybe we don't need to spend the money on a guardianship if it doesn't have to. So yeah, we were talking about 3 ways to handle children with special needs, and whether or not you needed guardianship or power of attorneys or even a limited guardianship. So that's it for today. And for our awesome listeners of this episode, we have a special gift. We are offering 10% off on any kind of estate planning needs for the first 5 listeners to mention this. Let the record show. Remember, if you have any questions about this topic or anything else regarding estate planning, probate, corporations, or the like, you can visit our website at www.sivialaw.com for our blogs and more resources. I'm Todd Sivia, the owner of Sivia Law, where we help you through life's transitions.